everybody. Welcome to Radcliffe Day 2012. I'm Liz Cohen. I'm the Dean of the Radcliffe Institute, and I am delighted you could join us for this celebration of Radcliffe. From the inspiring legacy of Radcliffe College to our present and future as the Radcliffe Institute for Advanced Study. We are also here to celebrate the achievements of Margaret Marshall, former Chief Justice of the Massachusetts Supreme Judicial Court, who will receive the Radcliffe Medal later today. It's wonderful to see so many of Radcliffe's friends assembled in one place to honor her with what promises to be a fascinating day exploring the role of the law in making social change. Thanks to all of you here for coming to Radcliffe Day, and a special welcome to those tuning in online. This is the first ever Radcliffe Day to be live webcast to our alumni and friends around the world, so that those who can't be here physically with us can nonetheless honor Radcliffe and Margaret Marshall. Most of you know, I think, that at this time last year, I had just been named interim dean of the Radcliffe Institute. So I eagerly attended Radcliffe Day 2011, taking notes, and soon thereafter began thinking about the shape of today's festivities. In the early fall, Karen Putnam, who's our Associate Dean for Advancement, and I met with Margaret Marshall, who had already agreed to accept the Radcliffe Medal, to get acquainted. We were pleased to discover, and a little surprised, I have to say, that as such an intellectually engaged honoree, she shared our desire to make the morning panel discussion a first-rate program. Together, we crafted the event you are now attending as a tribute to Margie's many years of working at the front lines and in the high courts to advance social justice, dating back to her days as an anti-apartheid student activist in South Africa and persisting through her service as the first female Chief Justice in Massachusetts' highest court. Although we'll have an opportunity to thank Margie Marshall at lunch, please join me in acknowledging her now as she is here with us this morning. Margie, would you stand? More about Margie later. I could not be more thrilled and grateful to the four panelists, all with Radcliffe and/or Harvard connections, who have graciously agreed to participate in today's program. Their work and particular fields of expertise highlight Margie's achievements perfectly. But they are also here to offer their broader perspectives on the possibilities and limitations of the law in affecting social and political change. Today's panel session is, in true Radcliffe fashion, designed as an interactive discussion among panelists and between them and you, the audience, as we tackle a topic of great importance for a democratic society like ours, where lawmaking, litigation, and judicial review are all crucial building blocks. The subject, I think, is especially relevant as we approach the election year, fraught with contentious social questions. I look forward to hearing what our panelists have to say about what the law can and cannot do to address deep and complex problems. Before we begin, I want to take a moment to thank our panelists for traveling to be here with us today and for taking time out of what I know are extremely busy schedules to prepare for today's discussion. Also, many thanks to our good neighbors at the ART for giving us the use of this Loeb Theater this morning. You will notice that we could give them an applause. You will notice that we are on the set of their current production about Woody Guthrie's life and music, called Woody Says. I can't think of a more appropriate backdrop for our panel, as Woody was a bard and a balladeer who articulated idealistic hopes for American democracy. I believe he would have approved of a program with, in its title, Front Lines and Social Change. And of course, many thanks to my friend, colleague, and fellow dean, Martha Minow, for agreeing to moderate this panel when she has had her own commencement to attend to. Martha is the Dean and the Jeremiah Smith Jr. Professor of Law at Harvard Law School. She is an expert in human rights and advocacy, privatization, military justice, and ethnic and religious conflict. Her recent books include In Brown's Wake, Legacies of America's Educational Landmark, Government by Contract, and Just Schools, Pursuing Equality in Societies of Difference. She served on the Independent International Commission on Kosovo, and she helped to launch the UN High Commissioner for Refugees program to promote peaceful development in post-conflict societies. In 2009, Martha was nominated as vice chair of the board of the Legal Services Corporation by President Barack Obama. With many honorary degrees and other awards that I won't go into now to her name, including this one I will mention, the Radcliffe Graduate Society Medal, Martha Minow is a highly accomplished, principled, and committed scholar, teacher, and dean who tirelessly devotes herself to making a better world. Please join me in welcoming Dean Martha Minow.
Good morning. No, we're going to do it again. Good morning. It's fantastic to be here. I can't imagine more of a dream team than the group of people assembled here on the topic of from front lines to high courts, the law and social change. And nor can I imagine a better topic to honor Margaret Marshall, our former Chief Justice of the High Court here in Massachusetts. She has been engaged at the front lines of law and social change long before that role, starting with her student days in South Africa. I've been told not to spend more time talking about her, and that is my regret, because I could spend the whole time doing so, but it is my great privilege to be here hosting this, moderating this panel in her honor. The topic of law and social change is a timely one in this country and in the world. Probably law has never been more important to the issues of change, nor at the same time is it less obvious what direction this country and other countries are headed in. I just want to identify one basic contrast that I know will permeate our discussion, and I am so eager to hear what people's views are. On the one hand, law is a tool for social change. Many people, myself included, became lawyers with the hope that we could use law to produce more equality, to advocate for people who had not been recognized by larger society. And certainly there are great successes. The role of law in the 19th century in this country on abolition and women's rights, and in the 20th century, well known. The progress made with disability rights, gay rights. On the other hand, and here's the opposite side, law is the tool of the status quo. Law is the tool of the state. When you think about anti-apartheid activity in South Africa, this contrast is absolutely evident. Lawyers at the front lines and the courts upholding apartheid. So it's with that tension in mind that I turn to our panel. I will give the briefest of introductions because I want to make sure we have most time for their comments and discussion. And I will start in reverse alphabetical order, which is also the reverse of the order in which they will speak. Kathleen Sullivan, who is my dear friend, former colleague, former dean of the Stanford Law School, one of the most brilliant constitutional lawyers and litigators in the country. But it's true, and it's not just because we're friends. The National Law Journal says so, one of the most, so does the Daily Journal, so does the, et cetera, litigator of the week, winner of many, many appellate arguments. She also has the clearest mind and can speak without notes, which I admire enormously. She currently... She currently is partner of an amazing law firm, Quinn Emanuel, Urquhart and Sullivan, and is a named partner of that law firm and is the chair of the firm's national appellate practice. Renée Landers, also a dear friend, is currently professor of Law at Suffolk University, where she heads the school's health and biomedical law concentration. She served in the U.S. government, and so I'm particularly interested in her views about the government posture on law and social change. She was Deputy General Counsel for the U.S. Department of Health and Human Services and Deputy Assistant Attorney General in the Office of Policy Development at the Department of Justice during the administration of President Clinton. An expert in health law, she is herself closely watching the U.S. Supreme Court's decision-making soon to come in the challenges to the Accessible Health Care Act. And so can't wait to hear from you, Renee. And Jennifer Gordon, I had to confess, when Jennifer, oh, you're in the wrong order. No? Greenhouse. Okay, sorry. Okay, sorry. So Linda Greenhouse remains to this day, in my view, the most perceptive observer of the United States Supreme Court. She covered the Supreme Court for the New York Times between 1978 and 2008 and won the Pulitzer Prize for that work. She is also a member of the Harvard Board of Overseers and deeply involved in Radcliffe. And her recent work looking at, for example, before Roe versus Wade, voices that shaped the abortion debate before the Supreme Court's ruling indicate that she's also quite an accomplished historian and observer of the complexities of law and social change. She has a new book on the Supreme Court, which I am happy to tout. If you have any interest in trying to understand this strange institution, you should get her book. And I'm so pleased that she's here and can't wait to hear what you're going to say. Jennifer Gordon, I did confess to Jennifer that when she was a student in my class some years ago, I thought, oh my goodness. Jennifer is brilliant. She came to law school already having been involved in the issues of immigrant workers, and subsequent to law school, she founded a project, the Workplace Project, a nonprofit center organizing immigrant workers, which is one of the best exemplars, in my view, of law and social change, not using the courts, using social movements to change legislation. The courts, of course, involved as well, but also to strengthen the capacities of the people affected in their own ability to make change in the world. A professor of law at Fordham University, she's also a recipient of the MacArthur Genius Prize and has been recognized in many, many other contexts. Can't wait to hear from you either, and we're going to start with you, Jennifer.
Thank you, Martha. So I want to talk today about law and social change in two very different contexts. One is the context of gay marriage, and the other, as Martha indicated, immigrant worker rights, where I've worked for such a long time. When I think back on law school, it seems to me that one of the most useful things I learned the first semester of first year from Martha herself. And that was not a legal concept, it was the concept of cognitive dissonance, which is the term that, as many of you know, the term that psychologists use for how human beings feel when they acquire some information that's in tension with their beliefs. So think maybe of a religious cult member who is convinced the world will end on a certain date, and then that date passes, and here the world still is. Cognitive dissonance creates a state of internal conflict, which human beings are driven to resolve through either a change in their beliefs or a change in action. So our religious cult member might refigure her beliefs so that she thinks she was spared so that she could spread the word for a longer period of time. And I want to argue that gay marriage represents, in meaningful part, a change in the law through cognitive dissonance. 8 years ago, everywhere in the United States, the law denied gay people the right to marry. Meanwhile, 9 million lesbian, gay, bisexual, and transgender people went about loving each other and living their lives. 8 years ago, an estimated 2 million children under 18 were being raised by gay and lesbian parents. And I would add that some of those children have grown up and have quite a lot to say about the relationship of their lives to the law. And if you indulge me in a moment of parental pride, a few weeks ago, my partner of 20 years my partner of 20 years and I married in Brooklyn, New York, our hometown. And my hat is off to our medalist for starting the trend that made our marriage possible. And I want to read a few lines from, we have a 13-year-old daughter and a 9-year-old son, and I want to read a few lines from our 9-year-old's speech during our ceremony. He stood up before the guests and he said, "I only realized how much some people discriminate against gays and lesbians when, in school, I wrote a persuasive essay to convince people that gays and lesbians should be able to legally marry. My mom showed me one of the cases that decided gay marriage should not be allowed. The judge said that the only reason for marriage is to have children. I thought that was ridiculous. I bet the judge didn't marry his wife only so she could pop out some kids. The judge also said that it's harmful for kids to have gay parents. Do I look like I'm living a dark, depressing life?" Today, judges, legislators, and politicians who have gay and lesbian relatives and neighbors have begun to come to the same conclusion. As the New York Times recently reported following President Obama's late endorsement of gay marriage, when it comes to support for gay marriage among leaders as much as among voters, whom you know matters much more than what you believe in the abstract. Because once you know gay and lesbian people and see our relationships to be the same as all others, once people who are not gay see gay people as like us or even part of us, continuing to support our exclusion creates an intense cognitive dissonance that demands resolution by changing the law, which in turn ratifies the inclusion of gays and lesbians in everyday society. Now, of course, this is a simplification of a very complex situation, yet to me it has the ring of something important and true. And I wish this mechanism were everywhere at work. But one of the things that has made cognitive dissonance successful in part at producing social and legal change in the context of gay marriage, that is that lesbian, gay, bisexual, and transgender people are born in near random patterns into families all over the country, and that they work across the spectrum of jobs, and with some allowance for clustering in gay-friendly neighborhoods, live across the spectrum of regions, that is still sadly absent in our society when it comes to the potent mix of race and class. Many people who have the formal power to make change live largely segregated lives, so the chance is minimal that they will come to know as an equal a family that gets food stamps, an undocumented immigrant, or a child who goes to an inner city school. So, for the past 27 years, as I have worked with and for low-wage immigrant workers, I've given a lot of a lot of thought to the question of how people like that, people who are too easy to classify as not us, how do the not us make social change? And what use is the law to them? Often, in my observation, its conventional use is limited. Immigrant workers may learn that they have a right to a minimum wage, but if they demand that wage, they will be fired and perhaps deported. They may be able to get a court to declare that they are owed money for work that they did, but then they find the judgment is unenforceable. Why is the law less useful? Because a lack of legal rights is not the principal problem of immigrant workers, although for many a lack of legal immigration status is. Their principal problem is a lack of voice and power. And in this situation, I've come to believe that we need to understand law as offering a toolbox in which each tool has to be used creatively to maximum effect with the goal of helping excluded people build the power and voice to demand change. Much as a carpenter might use a hammer not only to drive nails, but to prop open a door or pry open a can. So how is this different from the conventional understanding of what lawyers do? The standard narrative is pretty much that there's a problem, and some group of people calls in a lawyer about the problem, and the lawyer says, well, here are your rights, and here are some potential causes of action. The lawyer sues or appeals to a regulatory agency, and the lawyer wins, in which case the legal strategy succeeded, or the lawyer loses, in which case the legal strategy failed. The difference in the model that's currently being deployed by immigrant workers around the country is that although straightforward lawyering remains critically important, there are times when lawyers teach people about their rights not because that knowledge allows them to claim those rights, but because talking about their rights is the best starting point for a broader conversation about why rights might exist without being enforced, and about what needs to be done to close the gap. There are times when litigation is less important for the judge's ultimate decision than for the platform it provides for people to tell their own story in a public forum. And times when a group fights for legislative change, although they don't believe that Congress can give them what they truly seek, because the campaign will be an opportunity for its members to participate in the democratic process, and because they know that if a law prevails, a new one, it will become a jumping-off point for the next round of the never-ending effort to build a more equal society. Thank you.
Perfect.
So as Martha recalled, I covered the Supreme Court for a whole long time. And in the last few years, I've been teaching about the Supreme Court at Yale Law School. So I'm going to frame my remarks in a kind of a court-centric way as a slice of this broader topic. And the question of the ability of courts to effect social change is a very complicated subchapter of our very complicated topic. So I'm going to start by reading a little excerpt from the transcript of the trial in a case that was then called Perry against Schwarzenegger. This was the Proposition 8 trial about same-sex marriage in California. And as part of the very last day of the trial, the closing arguments, the Judge Walker, interrupted the lawyer who was arguing on behalf of same-sex marriage as he was about to start his closing argument to ask the following question. Isn't the danger to the position that you are taking, not that you're going to lose this case, either here or at the Court of Appeals or at the Supreme Court, but that you might win it? And as in other areas where the Supreme Court has ultimately constitutionalized something that touches upon highly sensitive social issues and taken that issue out of the political realm, that all that has happened is that the political forces that otherwise have been frustrated, have been generated and built up this pressure and have, as in the subject matter that I'm sure you're familiar with, plagued our politics for 30 years. Isn't the same danger here with this issue? And the lawyer, Ted Olson, said, I think the case you're referring to has to do with abortion. To which Judge Walker responded, it does indeed. So this frames the conventional narrative that we've heard a lot about, both with respect to Roe against Wade, 1973, and generally with the ability of the courts to bring about social change in contested areas. So the conventional view has come to be, watch out for the courts. Don't turn to our courts to foist on an unwilling public that has not yet reached a consensus some step ahead in human rights or same-sex marriage or back then abortion. That courts are dangerous, not only because they may rule the wrong way, I mean that's the fear of a lot of people right now with respect to the current Supreme Court, but that they may rule at all, not having anything to do with ideology. In other words, not that courts might make the wrong decision, but that they might make any decision. So I think this is a narrative, it's become very pervasive, and it really has deeply infected the progressive side of the street, where people are quite afraid of the courts. And when Ted Olson and David Boies went to court with the same-sex marriage question, with the challenge to Proposition 8, in California. This was very controversial, I know, within the gay community and within the progressive community in general. We haven't yet heard the last chapter of that. So you can debate whether courts ever are able to bring about social change. There's a school of thought that says that if you really unpack the situation, courts really just ratify social change, and they may do it too late. They're the trailing edge, not the leading edge, so that one might say that in 2003, when the court overturned, after 17 years, Bowers against Hardwick and ruled in Lawrence against Texas, that there was the Constitution protected gay relationships. You can say, well, hardly any states were still enforcing criminal laws against gay relationships, and so the court, kind of came in at the end. So that's one way of looking at it. Another way of looking at it, I think, is that courts have a great power to legitimate an idea just simply by ruling that something comes within a constitutional framework. Courts have a great power to cut through what you might call a democratic deficit, where there's a lockdown in a legislature. This was part of the case of Roe against Wade. You hear some people say, well, if only the court had stayed its hand, abortion reform was sweeping the country. And actually, that's not true. That's a myth. And Martha indicated that I'd done some historical research on the pre-Roe period. A lot of it just over here at the fabulous Schlesinger Library, which has the world's most fabulous set of original documents and resources on this question. And it really wasn't true. So I think it's interesting to just look at an issue that now seems to us completely settled, in a way of thinking about this question. In 1967, the Supreme Court ruled in the case of Loving against Virginia that it was unconstitutional to prohibit interracial marriage, striking down a law in Virginia. And what's very interesting about that is that most people were very opposed to that decision and opposed to interracial marriage in general. And it wasn't until 1991 that a plurality of Americans in polls said that they were not opposed to interracial marriage. The state of Alabama actually did not repeal its law against interracial marriage until a popular referendum in the year 2000, and the vote was 60-40. That meant that 40% of the people voting in Alabama would have preferred, if they could, of course they couldn't, keep a ban on interracial marriage. So, this raises the question, should the court have stayed its hand because there was not a powerful constituency in support of what the court did? So it's a very complicated question. My time is up. I'll just mention that people that, as Judge Walker did, I think with the best of intentions, reflect the narrative that watch out for the courts, whatever they might do is dangerous, really have to look at a much more granular level at the history of each particular dispute that you're drawing generalizations from. Because generalizations in this area are really tricky, because each one of these areas has its own history, its own politics. Roe against Wade was not wildly unpopular when it was first issued. In fact, Jerry Falwell, the head of Moral Majority, didn't preach his first sermon against abortion until 1979, and the decision came down in 1973. And so you have to ask the question, what was happening in those 6 years? And what was happening was a lot of political mobilization and decided effort at party realignment by very smart Republican strategists, but won't go into that now. But so it's just the ability of courts to effect social change is there. The ability of courts to create trouble when they try to do it is also there. And it's something that is, as we go forward into this very tricky time of major Supreme Court rulings hanging in the balance, worth looking at and thinking about with great care and attention to the actual facts of each matter. Thank you.
Well, it's a pleasure to be here with all of you and with all of the other members of this distinguished panel. I want to give a shout out to some of my classmates who may be in the audience, but the disadvantage of being in the theater is that I can't see anything in the audience because of the lights. But there's a competing event for our reunion, and if any of my classmates are here, I thank them very much, instead of listening to Drew Faust speak. So thank you for coming. Well, relating, I'm going to take a slightly different approach, but I think what I'm going to say will resonate with the themes that the other speakers so far have started talking about. Relating the story of my life and my career is a good way in some ways to talk about the capacities and limitations of the law in affecting societal change. As I've already indicated, it's my 35th reunion, so my age is no secret. And I was born the year after the Supreme Court decided Brown versus Board of Education. And this decision marked the culmination of a carefully orchestrated legal strategy challenging unequal segregated educational facilities and opportunities at all levels of the educational system in the country. And that story is very familiar to most of us. And at the 50th anniversary of the Brown decision in 2004, I wrote a piece about how Brown transformed the country from a society where African Americans were effectively barred from almost every interaction in the public sphere with whites. African Americans were barred from voting, holding public office, serving on juries. African Americans were forced to use segregated municipal pools, parks, libraries, denied access to public accommodations in hotels, restaurants, dressing rooms, and retail stores in many parts of the country. And as Linda has alluded to, interracial marriages were prohibited by law in many states. So Rosa Parks' refusal to give up a seat on a Memphis city bus was, in the words of the Neville Brothers song, the spark of our freedom movement. The Brown decision gave activists and lawyers the confidence that the courts, and perhaps maybe misplaced confidence subsequently, that the courts and the legal system would give effect to the values and ideals enshrined in the Constitution. So the possibilities and the things that have happened in my life, my parents' marriage, although Illinois did not have an anti-miscegenation law at the time of the Loving decision, and my own marriage, many things that have happened to me would not have been possible without the activism of the 50s and 60s and in the courts reinforcing the values of the Constitution. Now, the irony here is that, of course, all these things could have happened right after the adoption of the 13th, 14th, and 15th amendments to the Constitution in the post-Civil War era. But the Supreme Court chose to attach limiting interpretations, allowing the states, in many respects, to continue segregation, for Jim Crow to flourish in explicit legal rules barring equality among the races, and then in allowing other more subtle forms of racism to persist. So on the one hand, Brown decision is a really great story about the courts taking an unpopular decision on social policy and giving effect to individual rights, but it was, as Linda has said, perhaps a little bit too late in the coming. After law school, I clerked for one of Margaret Marshall's predecessors as Chief Justice to the Supreme Judicial Court. And at the time of that I clerked, there was a new movement afoot in the states, mostly at the time, to have the state Supreme Courts examine the role of gender bias in legal rules affecting all kinds of decisions in the legal sphere and decisions of which the courts had to give effect. And so the question came to the then Chief Justice, Edward Hennessy, would he please create a gender bias study commission to examine the role of gender bias in the operation of the Massachusetts court system? And so, as judges often do with their law clerks, he had a conversation with me about, what he should do. And one of the questions his question to me was, I agree that there's a problem here. Why can't we have a commission to solve the problem? To think about ways to solve the problems of gender bias in the courts. And I said, you are unique in thinking that the courts could improve themselves at the time, that the value of the gender bias study, as Jennifer has alluded to, is sort of educating people about what the problems are, wherein bias exists, and that would really be the function of the gender bias study, and only then would the system be prepared to talk about possible ways of addressing the problems of bias that the study identified. So one of the things, I sort of said these things, a recent law graduate, I had no idea what I was really getting myself into, because a few months later, when the Chief Justice decided to create this commission, I get the telephone call from his executive director asking me to serve. But it was really a transformative career experience for me, because I learned really to take a much more skeptical view of legal institutions. And I learned really what Martha Minow was saying earlier, that law truly can be a tool for reinforcing the status quo. And what it really taught me in that experience, Martha Minow gave me the words to sort of identify what I learned in work that she has written. Really examining what it means to be different and what people's assumptions are about difference. People assume that difference is intrinsic and not in comparison to other things that people are used to. She's talked about how people assume normal states of affairs and don't describe what people perceive as normal and why we should be worried or not worried if things or experiences don't conform to what our notions of normalcy are. She has also taught us to really question our perspective, to really challenge notion that any observer can see without perspective, that we all have biases that we're bringing to bear on subjects. And to learn and to appreciate the perspectives of others, that they're not irrelevant in examining these issues. And there's going back to the issue of race discrimination, some of the early cases, or some of the cases in the 19th century that dealt with this issue, really went out of their way to say that the construction that African Americans, that blacks would put on laws enforcing segregation were really not relevant. It was their problem if they viewed those laws as problematic. So therefore, just sort of, assuming that the white perspective was the accurate one. And then finally, that the status quo was uncoerced, natural, and good. That the law had nothing to do with creating the situation that we've all grown used to, because it just is what we have experience with. So it was I'm embarrassed to say, it was such an eye-opener to me to see how the law really can subtly reinforce our existing power structures, and that the law fails many times to acknowledge the role of government in action as well as action in contributing to social policy. And the courts, as part of the government, have a role in this as well. So going back to the Brown versus Board of Education case, the Brown case, obviously, I think the country was better off that the court decided that case in the way it did, because it opened up huge spheres of possibilities, as I've already indicated. But then the courts became worried about, I think, the public reaction, and actually sort of started erecting legal barriers to really giving full effect to the promise of Brown. The courts, another legal scholar has done some really careful work on this and identified how the courts have shut down avenues that would have promoted more integration in public schools by prohibiting suburban city integration remedies, by refusing to declare education as a constitutional right, a fundamental constitutional right under the Constitution, and refusing to say that inequities in funding create constitutional problems that unequal access to education, and by ending desegregation orders too soon, before school districts had really internalized the habits of running fully integrated and equal schools. And so what has happened as a result of some of these policies, and also public resistance to integration, the resegregation of our schools. In a 2003 Supreme Court case, Justice Ginsburg wrote a concurrence noting that more than 70% of children in schools in the United States attend schools that are very highly segregated, very imbalanced racially. And a lot of recent evidence is emerging that students who attend integrated schools have higher educational achievement. And so we have not solved the problem that Brown was addressing in 1954, even though quite a bit, almost 60 years have passed since that time. In the Boston Bar Association, I'll tell one other connection for social change before I conclude, is that I've been very active in the Boston Bar Association. And one of the goals of the Boston Bar Association, it's spent a lot of time and effort over the last several years trying to address diversity in the legal profession. The sad story here, similar to the story on the resegregation of public schools, is that even though law schools have been graduating more diverse populations of lawyers, the statistics on partners in law firms, for example, and the achievement of people in the legal profession are still very disappointing in terms of the numbers of women who achieve higher ranks in the private sector side, and the percentages of minorities, people of color, who achieve those landmarks. And so the law and the legal profession has tried some sort of soft policy changes, filing amicus briefs, running programs, but those have not been totally effective in changing the status quo of dominance by whites in the legal profession. A final point, I was asked to speak a little bit about the healthcare situation. And healthcare raises another interesting aspect of this problem. The court's considering a challenge to the Affordable Care Act on constitutional grounds, that the way the statute is structured exceeds Congress's power to act under the Constitution. And the courts the Supreme Court is being asked to reconsider, I think, reconsider 60 or 70 years of pretty settled law on the extent of Congress's power under the Commerce Clause, but we can have a discussion about the details of that as part of the discussion of the panel. The debate has been framed on theoretical principles, that the statute is an affront to liberty, rather than Congress, the statute being an effort of Congress to try to provide a means for people to actualize a value, of leading healthy lives, having access to health care that we're perfectly capable of providing to everyone, and not framed from the point of view of health care as a right that's central to the exercise of other rights as a citizen. It's similar to education in that respect. If you don't have health, you don't have access to health care, it's hard to think about public policy issues, to go out and vote, to participate in the life of the community. And so I think that the framing of the issue and the way in which courts deal with the way these issues are framed as sort of abstract legal concepts sometimes gets in the way of really recognizing what's going on. I didn't bring this quote with me, but one of the, I think, more insightful comments about the role of the courts with regard to reviewing the Affordable Care Act was written by a dissenting judge in the D.C. Circuit decision on upholding the constitutionality of the Affordable Care Act, but the dissenting judge would not have decided the case at all. And he made the point that the political branches of government are trying really to solve a very complicated social problem. And perhaps the courts should take a step back in this instance and let things sort themselves out, see how the law works, see where it goes before deciding on the basis of a legal principle that the government does not have power to act to solve a pressing social and economic problem. So I look forward to the discussion. I think I've raised, my intent was to raise a lot of questions about, on the one hand, the opportunities for courts to act, to give effect to social change, but then what some of the limitations might be in actually making those changes a reality. Thank you.
It is such an honor to be able to be part of this wonderful panel with Dean Minow, Dean Cohen, and these members of the Radcliffe community, and to honor Chief Justice Margaret Marshall and her historic tenure as Chief Justice of the oldest state Supreme Court in the nation, the Supreme Judicial Court of Massachusetts. Historic for many reasons. We were all schooled on Marbury versus Madison and McCulloch versus Maryland, authored by Chief Justice John Marshall, whose statue sits in the basement of the Supreme Court as the foundation of constitutional law. But now, when you say Chief Justice Marshall, you have to follow it up by saying, Margaret or John? So thank you, Margie, for all you've done. And I'd like to pivot off some of the remarks of earlier panelists by focusing on Chief Justice Marshall's historic 2003 Goodridge decision, which held that under the Massachusetts Constitution, same-sex marriage was constitutionally protected. And I'd like to frame the discussion by giving you 3 quotes and then ask what changed between the first one and the second 2. The first quote comes from a brief that I was privileged to co-author with my great dear friend and teacher and colleague, Lawrence Tribe, back in 1986. Here's a flavor of what we wrote in that brief, which was the unsuccessful brief in Bowers versus Hardwick, challenging a Georgia criminal statute against so-called sodomy. At issue in this case, we wrote, is whether the state of Georgia may send its police into private bedrooms to arrest adults for engaging in consensual, non-commercial sexual acts with no justification beyond the assertion that those acts are immoral, said we, but our constitutional tradition does not permit such casual state control of our most private realm. 1986. Fast forward to 2003. Let's stop first in June in the United States Supreme Court, where a majority of the now United States Supreme Court, overruling Bowers versus Hardwick and saying it was wrongly decided at the time, writes, the case does involve 2 adults who, with full and mutual consent from each other, engaged in sexual practices common to a homosexual lifestyle. So the decision wasn't perfect. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Justice Kennedy's magisterial words for the court in Lawrence versus Texas, overruling Bowers versus Hardwick. And then a third quote, this time from Chief Justice Marshall, writing for the Supreme Judicial Court of Massachusetts with respect not to a sodomy law, but now to same-sex marriage. The question before us is whether, consistent with the Massachusetts Constitution, the Commonwealth may deny the protections, benefits, and obligations conferred by civil marriage to 2 individuals of the same sex who wish to marry. We conclude that it may not. The Massachusetts Constitution affirms the dignity and equality of all individuals. It forbids the creation of second-class citizens. Now, what changed between 1986 and 2003? What happened in those 17 years? I look back, and the very first case I'd worked on with Larry Tribe, we represented the rights of people to proselytize at a state fair. We challenged the booth rule. We said this was discrimination against unpopular causes. The Supreme Court, Justice White, the author of Bowers versus Hardwick, wrote that our idea was interesting but has little force. We lost. When we lost Bowers, the same justice writing for the court wrote that the idea that homosexual sodomy is a right, a fundamental right protected by the Due Process Clause, is at best facetious. I turned to Larry and said, don't you long for the days of interesting but little force? So what made an idea that seemed at best facetious one day become the law of the land the next? Well, there was a social movement that was galvanized in part by the loss in Bowers versus Hardwick. People advocating the repeal of sodomy laws in the state legislatures or their challenge in state courts. People advocating the rise of same-sex marriage and its legitimization took off from Bowers versus Hardwick as something to be corrected. So sometimes losing constitutional litigation in the courts can galvanize a social movement. That's part of it. And part, of course, is also a cultural shift, the cognitive dissonance Jennifer described so eloquently earlier. I was talking with a dear friend about what had happened between Bowers and Lawrence, and she said, well, it was will and grace. And I said, you mean the will of lawyers and the grace of judges? I just don't watch much television. And she said, no, Will and Grace. I said, yeah, the television show. What television show? There's a television show with a prominent gay character, and there are others. There have been lesbian plots on Friends. I said, you've got to be kidding. I've been very busy the last number of years. But obviously, cultural shifts and the legitimization of a topic in popular culture and knowledge of people who you then can't deny rights to as citizens that you would give to them as your neighbors and friends, that's part of it. There's one more piece about what changed in the meantime before Goodridge, and that's our understanding that federalism includes blue states' rights too. That states' rights, often viewed as a kind of rallying cry for conservative and anti-progressive social forces, misunderstands the important and galvanizing role of state constitutions and state courts in this social dialogue. Linda alluded before to Loving against Virginia, 1967, the US Supreme Court striking down on federal constitutional grounds laws forbidding interracial marriage that Renée alluded to as well. But it was Perez versus California in 1948 in which the California Supreme Court struck down interracial marriage bans in California. And the state courts had, in many other instances, gone beyond the federal constitution in protecting against unreasonable searches and seizures, or protecting the rights of newly freed slaves, or abolishing the death penalty. So the importance of federalism and an understanding that states can change things before necessarily the entire nation is ready to change, that's part of the story too. But I just want to conclude and maybe pull together some of the themes that have already been discussed so beautifully by the panelists by saying why it's important to keep courts in the equation for the forces of social change. It's often popular, especially among progressives, to say courts merely come afterwards, or as Linda described this point of view, merely legitimate or put an imprimatur upon social change that's already been achieved through other means. I think that's incorrect. And I think that progressives who want to use law to achieve social change give up on the courts at our peril. And let me just describe two reasons why I think courts and constitutional litigation in courts remain so important. First, the matter of language. When you litigate a constitutional claim in court, you litigate in the language of rights, not of interests, in the language of a claim that is based on a moral entitlement that is broadened across more people than just yourselves or your own cause, that actually extends back in time and forward in time to others who you can't even yet imagine will invoke that principle, that has precedential force, broad enough and vague enough to encompass things you cannot yet foresee. That was what the framers meant by a broad and vague set of commitments in the Constitution, the capacity for evolution, not just in a president's thinking or a social movement, but evolution in the way we understand our rights. And that is speaking in a different language. And second, constitutional litigation enables people to speak that language in a forum that gives it force, that enables a constant dialogue between social movements and constitutional litigation, between the two forces Martha described at the beginning, the forces of social change, which are anti-authoritarian, and the forces of precedent and inertia that reflect the status quo. Without the constitutional litigation to speak in dialogue with the people on the streets, without the bookends that Margaret Marshall's life represents, beginning with social protest among activists in South Africa against apartheid and ending on the bench, without the dialogue between those two forces, neither can be as effective as it would be otherwise. We know the courts couldn't be effective without the social activists, to include the constitutional litigators, but my argument to you is that the social activists can't be as effective without the language that is spoken in court. When Judge Walker heard evidence in the Prop 8 trial in California that asked people to speak not in the food fight dialectic of the cable television shows, but in reasoned language about what justification could there possibly be for forbidding same-sex marriage, that language in a courtroom becomes an important counterpoint to language in the street. It's the language of right and not interest, and it's the language of objectivity and reason, not simply personal claim. So I would conclude just by saying courts, constitutional litigation are as important in this dialogue as social activism is to courts. Obviously, they need each other, but those who say, well, courts are just a force for lagging and putting an imprimatur on social change, I think are both historically wrong and give up a tool at our peril. Thank you very much.
This is a fabulous panel. You can see why it's the dream team. We will now try to have a bit of discussion among ourselves while you share your comments and questions. People are walking up and down the aisles collecting cards. My first question actually is an effort to see a connection across all of the very interesting remarks. And it is to ask you whether what law offers to social change is less decisions or authority than a forum or an arena for debate. Because I heard a theme about that in each person's remarks, but I'd really be interested to hear more about that. So Jennifer, you talked about the possibility of a starting point discussion about what are rights and why do they exist and how to address the gap between rights and enforcement. My particular twist to you is whether the educational enterprise can avoid the disappointment and the cynicism in seeing the gap between the rights and the enforcement. Does education actually produce cynicism? Or how can it be framed so that people aren't dispirited? Linda, you also explored the way in which there is an educational opportunity that the courts can provide a kind of arena, and it was terrific to, as you did, include Judge Walker's own concerns in some sense of his own education about the backlash against court decisions. Let the record show that Judge Walker made the decision to strike down Prop 8. So the arena inside the courtroom may provide an avenue for reason, even when politics may be pushing in another way. So my question for you is what it takes for the interior of the courts to provide an educational context that is different than what goes out there in the food fight. And Renee, your very powerful and insightful comments, both personally and then professionally, it raised for me, using your experience on the Gender Commission, whether the forum for education that law offers, we should understand more broadly than the formal institutions of the courts and the legislatures themselves. And for Kathleen, when you talk so beautifully about this dialogue, I shall say, with no notes, the only notes were about the quotations that you read, the dialogue and the change that's occurred over the last 17 years, your reference to will and grace seems to me a very telling one. So what do you make of the role of mass media, of the internet, as the arena in which education or something more like propaganda about law is occurring? So those are variations on the general question. Who'd like to start?
Okay, I'll start. So, one thing that's rather unique about courts, and I think this is relevant to our current concern about what the court's going to do with the Health Care Act, is when the court decides a case, it gives reasons. I mean, when an agenda disappears from view in Congress, for instance, it doesn't necessarily leave a fingerprint. But what courts do, individual judges who write opinions take accountability, they put their names on it, and they have to explain it. And those explanations can be quite powerful and can either be a force to mobilize against. I mean, the notorious Justice White line in Bowers against Hardwick, this is a facetious claim, did, I think, really spark a powerful mobilization against that decision. And so, it's a unique ability of the court to sort of frame an issue. I'll just mention one case that has come to my mind, in part from what Renee said. So there was a case in 1982 called Plyler against Doe. And the question was, does a state, in this case Texas, that provides a free public education to children, have to include in that free public education undocumented immigrant children. And Texas had passed a law that was going to exclude these children from public education. And this case was initially framed, it was a movement, it was a social movement case. It was kind of the end of the line of a progressive social movement of its era. And it sought a ruling from the courts, and from the Supreme Court in particular, that education was a fundamental right, and as kind of a secondary issue, that poverty was a suspect classification, and that any law that seemed to discriminate on its face against people on the basis of their wealth was highly suspect from the get-go. Flagler against Stowe achieved neither of those goals. It refused to declare education a fundamental right, and it refused to unsettle a recent Supreme Court decision that had ruled out wealth as a suspect category. But the court ruled that, that regardless of citizenship, all children had a right to a free public education. So doctrinally, you know, that case went nowhere, but I'm here to say that but for that law, undocumented immigrant children would have been thrown out of schools across the whole belt of anti-immigrant states in Arizona and Alabama and South Carolina, and they're only stay in school because of that long ago Supreme Court decision. So again, it's just a piece of this big puzzle and this big dialectic and dynamic in which courts are part of our conversation. And as Kathleen said, you know, they've got to stay there.
So Martha began by asking, are courts and legislatures more important as a forum than for the decisions they make? And for all that the forum is very important to me, I would have to say that if we don't have the decisions they make, we have nothing, right? What's the forum for? The forum is to reach some marker that is some measure, however imperfect, of where our society is on an issue. And I think it's the recognition of that, right? It's not a perfect marker. It may not be, in an individual's view, an accurate marker of where things should be, but it preserves the gains so you know where you are. And I think that's part of what shapes my answer to the question of how you avoid cynicism if your goal is, as mine has so often been, to use rights as the starting point for a discussion about how you make change. And I think if you're with a group of people, right, individuals, that's a different thing, but a group is a powerful thing. And you ask that group to reflect on their reality, what is their experience, and then the group goes through a process of comparing their experience to what the law says they should have a right to. Right? In my experience, usually they're getting less than what the law says they should have a right to. And then asks the further question, what would justice look like? Right? So we have reality, we have law, and then there's another marker. What would be a just world in the view of this group? That's a process that groups everywhere that have sought to make social change have gone through. And the way to avoid cynicism is to talk about how groups over time have moved from reality to law, to moving the law a little closer to justice. And in many ways, you know, I think that the point that Linda made, that context is everything, she didn't say it exactly that way, but I took that as her point, is one that I believe very powerfully to be true. But I also think, to paraphrase Dr. Martin Luther King, the arc of the universe is long, but it bends toward justice, right? That process, learning about rights and thinking about how to change the law is a key part of moving that arc.
So your question to me was about, you know, the conversation, is the forum broader than just the litigation forum of being in the courts? And I can give, I think the answer to that question is assuredly yes. And one of the opportunities offered by having the courts consider important cases that raise these societal issues or challenges to the status quo is that it really does engender and spark a public debate about the relevant issues. Going back to Martha's specific question was about the gender bias study, and the results of the study did spark a public debate about how courts deal with situations of domestic violence without, issuing restraining orders. What were the right processes to protect women but not to interfere with other rights? Really interesting and useful public debate that resulted in helpful legal changes, although I think that maybe there's been some backsliding there too. But that really sparked a very powerful public debate that resulted in useful changes in the law, and the debate involved all elements of the legal system, from law enforcement through courts and the social service sector of the community, as well as ordinary people. A second example is going back to the same-sex marriage issue. I was the president of the Boston Bar Association in 2003, 2004, when the Supreme Judicial Court decided the Goodrich case, and then it went into effect in 2004. I had untold requests for public speaking from community groups trying to understand the legal issues and what the impact would be on religious organizations, community groups, other kinds of social situations. So it was a real opportunity to explain to people that, their fears were not going to materialize because of the court's decision. And without the decision, there would not have been that opportunity for those conversations. It really caused the community groups to try to understand what were the rights, what was the law, what was the just solution in those situations. And then finally, on healthcare reform, I think has had that the Supreme Court's consideration of the constitutionality of the Affordable Care Act has had the same kind of effect by engendering a great deal of public debate. I actually listened to all of the oral arguments, and I've read all the transcripts at least once. In those oral arguments.
5.5 hours of oral argument.
Yes, exactly. And the mischaracterization in the media of many of the things that happened, just for sort of taking the sound bites that would make, sort of good fodder for the evening news or the noontime news, was really interesting to me. So with all due respect to Linda's profession, I'm not sure I'll ever really quite read the newspaper or listen to the media accepting a mindset again. I mean, I knew that I should be a critical reader and all that sort of thing. But, and so because I had very different takeaway points on a lot of the discussions and a lot of the arguments than were portrayed in the media, and that have been sort of now commonly accepted as what happened during those oral arguments. So I think that having the opportunity to be able to talk to reporters and to sort of put forward this alternative interpretation of these events has been a really good one. And again, without the litigation, that opportunity wouldn't be there, the opportunity for misperception, but also the opportunity to try to correct those misperceptions.
On the arc of justice, a court generally can't change things by starting at the beginning of the arc. It comes along onto the arc at a place where there's just enough, as Martha's question to me asked, enough movement in popular culture and the zeitgeist so that when it speaks, it can do so with some legitimacy, a legitimacy that Lawrence and Goodrich claimed from the changes in state sodomy laws by legislation, the changes of approaches to human rights in European countries, the changes of views about gay people by the medical profession. There has to be some reference point outside the court that gives the court a sense of legitimacy, because it is the weakest branch. It has only reason. It does not have sword or purse. So it can't usually be at the very beginning of the arc. It has to come along where there's some propulsion that it's able to point to outside the mere reason that it's using to bring to the table. But don't underestimate the way in which the court then accelerates the finishing of the arc, that the court brings movement and propels forward the movement of that change. It doesn't just come in at the end. This is a very elitist view. It thinks because minds have changed on the coasts, Minds may have changed elsewhere. When the court I did a case very long ago with the Oklahoma ACLU, a small but hardy band. And it was a challenge to an Oklahoma law that banned the encouragement, counseling, or encouraging or advocating homosexuality by public school teachers in the curriculum. A law so vicious and restrictive that Ronald Reagan had vetoed it when he was governor of California, when people tried to pass it there. And we were trying to challenge it, again, and it was my privilege to work with my colleague Lawrence Tribe on this, and it was a time when there was really not a language yet that was clear about where gay rights was going. Was it an equality problem? Was it a privacy problem? Was it a free speech problem? Or, as one of the members of the Oklahoma ACLU suggested, maybe we could just solve this by looking at the religion clauses. Say that homosexuality is a religion and has free exercise, and heterosexuality is an establishment. So it was a time when there really wasn't a language to speak in the way that we now take for granted. But when Lawrence came down, obviously Goodridge was taking care of people in Massachusetts, but when Lawrence came down at a national level, it was able to move Oklahoma to where Massachusetts might have been on its own. That's the language of a national constitutional order. So I do think that Martha's right. There has to be a cultural ground that has been laid before a court can speak in its way, absent sword or purse, and be effective. But don't ever underestimate the way it can change the lives of many people whose lives wouldn't have been changed but for the court.
Terrific. We have a majority of the questions sent to me from the audience that in one way or another ask you all to reflect on the current Supreme Court of the United States. And so let me give you a flavor of these questions. They include a question about whether the Supreme Court that's currently there is one that anyone interested in gay rights would want to have consider that question. They include a question about whether the courts allow public officials to avoid actually confronting issues by leaving it to the courts. They include the question whether strict constructionists, that is, an interpretation of the Constitution that looks not to the evolution that Kathleen Sullivan described, but to some notion of the plain language of the words as defined by dictionaries at the time of the enactment or some other limited conception, whether that philosophy that is held by some members of the court is problematic for the views that are expressed here. And they also include kind of a general view of whether the evolution of law and rights is something that is a dialogue with this court, or is this court against the dialogue and is more interested in shutting down the conversation?
No opinions in the audience, that's for sure.
Yeah. Well, I mean, I think I tend toward the last question, the sort of dialogic one. And that really, I think, you know, we've all said that in our way. You know, I wouldn't give up on this court in terms of the gay rights question, for instance. I mean, it's been, I think, certainly a good thing that it's now going on 2 years since Judge Walker's district court ruling in the California case. The final appeals before the Supreme Court level have yet to run their course because of various technical issues that came up. And a lot has happened in those 2 years because the Proposition 8 case, you know, as we've said, did sort of frame a society-wide discussion. And there's now, all the polls indicate, there's now a majority of the country who support same-sex marriage. That was far from true, even in 2010 when that case came down. And, you know, I mean, I don't think it's, you know, people say, well, the court follows the election returns. I mean, not in a reductive way, but I think the court lives in the world. And the difference in the 17 years between Bowers, when Justice Powell, who cast the deciding vote in that case, famously said to his closeted gay law clerk, who he didn't know was gay, I don't believe I've ever met a homosexual. In 1986, to 2003, when gay people were out all over the place inside the Supreme Court and as leading members of the Supreme Court bar. A lesbian top assistant to Chief Justice Rehnquist, who came to court events with her partner and their 2 interracial children. I mean, it was just a different life in 2003 that the justices were living because of the, context that they were living in. So, we can wish there was a different Supreme Court right now. I think many of us in this room might perhaps wish that, but the court lives in the world and it's a dynamic institution, and we're in a very dynamic, kind of fluid pressure point in society right now, and it's just really interesting.
I guess I would say one other thing about that. On the race question, I think it's a more complicated story perhaps, because I think that in a case called Parents Involved against Seattle Independent School District, if I get the name of the case right, a few years ago, the Supreme Court really indicated that it was not interested in having race-based remedies. I'm grossly oversimplifying here, in school assignments in public school districts, unless there was some demonstration that there had been a constitutional violation, legal enforcement of segregated schools. So, and Chief Justice Roberts famously wrote in the majority opinion in that case that the way to stop discrimination on the basis of race is to stop discrimination on the basis of race. And I interpreted that statement as not really being consistent. It was with my experience in the world. And I think part of it is what Jennifer was talking about how the divisions of class and race are really profound still in the society. And most members of the Supreme Court probably don't deal on a regular basis with a lot of people as equals who really must send their children to urban public schools that have a lot of problems. And so I think that I'm worried when the court has decided to take another affirmative action case involving the University of Texas admissions standards and process. And I'm worried about what's going to happen with that case, because I'm just not sure that they understand how much implicit race discrimination is still part of American life.
We are coming to the close of our time together. I have to say the questions keep coming in, and they are excellent. And maybe with the new wonderful online streaming, there can be an interactive continuation of this discussion. I also have to say it's some of the best handwriting I've seen in a long time. There are a couple of questions, though, that I just want to summarize here for the panel and see if anyone wants to say something. And they're from recent law school graduates or current law students who are asking whether there are prospects, you think, right now for using law for social change, and in particular, given the financial difficulties that many young lawyers are facing. Is this something that people should aspire to do realistically?
Yes, absolutely. I'm a former law dean, and I have an unequivocal yes to that. And I want to broaden the sense in which we talk about social change. We've talked so far mostly about constitutional litigation, but law creates social change in so many other forms. We're creating social change right now through intellectual property law that determines how freely information is accessible through new digital media. That's determined partly in the crucible of patent litigation and copyright litigation and trademark litigation and litigation about importation of foreign products. So it's too narrow a scope to think, well, I'm a lawyer, I want to work on social change, I have to do constitutional litigation on the great model of Thurgood Marshall or Ruth Bader Ginsburg. That's not the only way that a lawyer can participate in social change. So we have an immensely complicated and globalized world in which social change happens through legal mediums not limited to constitutional law. And that world is booming away. The amount of, the rapidity of change and the quantity of litigation in that world with respect to the area of information. What could be more important to a democracy? So my first advice would be, yes, young lawyers can go make social change. Don't rule out that you can do that through multiple forms of private litigation that help create the world we live in. That's
Fabulous. One other comment that's worth noting, someone shared with us, is that if we didn't have Title IX, we didn't have other recent changes, we probably wouldn't have been able to have this panel. And I think that's an awfully good point.
Oh, can I say one word about the Radcliffe Institute? So I think many times I've been reminded during this conversation of Radcliffe Institute programs that have occurred, that have addressed some of these topics. A few years ago, when Barbara Gross was the dean, she had a program on gender and the law that was very effective. It drew people from all over the world to talk about the role of gender in the law and the role of courts in changing the law and advancing women's rights. A second program that really stuck in my memory was a program on the anniversary of Title IX a few years ago, where the Institute brought back Cordis Collins and Birch Bayh, who'd been the House and Senate sponsors of Title IX legislation. And it was a remarkable insight to the quality of discourse and public service that perhaps existed during that time that the legislation was passed. It was at a different level than sometimes we're accustomed to hearing these days. So I think the Radcliffe Institute, I just wanted to say that the Radcliffe Institute has a really great role in promoting information about this.
Well, in that spirit, I want to close by saying a year ago when Liz Cohen became acting dean of the Radcliffe Institute, I had a scream of joy because I have such an admiration for her. And now that she is the dean, I cannot tell you what a great, great boon this is, not only for the university and the Radcliffe Institute, but for all of the topics that we are talking about here. And so as we draw this to a close, I look forward to many more wonderful events under Liz's leadership, and thank you all for a fabulous discussion.